question is whether Zondo is fit to preside over the matter. Being a presiding officer, he must be independent, he must not be biased, and there must be absolutely no conflict of interest at any stage whatsoever. That being said, the person that brings the application bears the onus of proof. The onus in this instance is on Zuma and his legal team to persuade the court on a balance of probabilities. So it's not the highest degree of onus of proof that we typically find in our law in criminal cases. It's a lower threshold. In this instance, it's based basically on, first of all, a constitutional issue, stating that, first of all, the commission is not properly constituted in terms of the findings that in the report of Tuli Maronsela come some years ago. Second of all, that Chief Justice Mogoeng did not have the necessary authority to make the appointment. And the second line of argument is that there was an interpersonal relationship between Zuma and Zondo. The third one, if all else fails, remember, we're actually more than that. We're actually family members, because one of my wives, Tubeka Madiba, is actually a direct family member of Zondo. And then more than that, the last argument more or less is that he says, listen, if one looks at the evidence that was led up to now, it's clear that the commission picked certain witnesses, and certain witnesses were not chosen to come and testify. And it's clear from the type of questions that you ask presiding officer Zondo that you already made up your mind.
Before we answer the question of the legitimacy of this application, explain to us the mechanics of an application of recusal as it is in the law.
It's actually a very simple application. It's based on a motion, usually in writing, like we have seen here, supported by an affidavit. And then it's an oral argument. And then the judge stands down, he considers it. In this instance, he said he would give judgment a day later. Ultimately, it seems that he needs another day, so he took 48 hours before he will give his judgment. And then that's it. Either he agrees with it and he will grant the application, and then, as far as I'm concerned, that's the end of the commission. I'm not sure that in this instance he will be in favor of standing down and recusing himself. I'm not certain there's sufficient evidence to support that.
That's what I want to ask now. Can you, with the evidence available at the moment, how legitimate is the application?
There's definitely merits in some of the arguments. Whether it's sufficient, remember, there's an onus to be established. Balance of probabilities. Now, balance of probabilities on a scale of 50-50 means 49-51 at least. So anything less than that is insufficient, even if there is prima facie evidence. In other words, at first look at it, first glance, it seems that there might be some merits in some of these arguments. Is it sufficient to weigh in favor of the one party against the other party? I'm not persuaded from what I've seen, and this is one of those instances where it's sufficient that for successful recusal application. The law expects him to man up and to say, listen, I've considered the evidence and I do agree or I disagree. He's got a discretion, and his discretion will not easily be overturned on and later review or appeal proceedings. Even though, in this instance, what happened here is that the lawyers for Zuma already indicated that if the judgment does not favor them, they are going to take the matter on review. That means we are in for another battle in a later court for another couple of months, just to establish whether the recusal application was correct or not. And lo and behold, if that does not suffice, they indicated they're going to do the same that Dudu Munyeni did. In other words, they're going to make use of their right to remain silent. And in this instance, at least on that aspect, I do agree with the sentiments raised by the lawyers of Zuma. He is entitled to remain silent. Whether that amounts to Stalingrad techniques, that's another issue, but the fact of the matter is he's incriminating himself, or there's a possibility that he can incriminate himself. He already stands trial in the High Court in Pietermaritzburg on certain charges of corruption, etc. So he is the one person that can legitimately deny to answer questions, anything relating to incriminating himself that might come into play later on at his hearing in the criminal matter.
Dr. Llewellyn Curlewis, thank you very much for your time.
Pleasure.
I appreciate it.